Got back just right in time. Sorry I'm late, people. And I am late, people. Let me just pull up. So if anybody wants to actually discuss the decision, you can come on to the live stream and we can have a sort of discussion. Or if people have comments or questions, please include them. And I go. Okay. I did a live stream when the decision was leaked. And we discussed things. And from what I've read, the actual decision is pretty much the same as what was leaked. There are two concurrences, which both are actually important. So it says Alito J delivered the opinion of the court, and apparently it's substantially the same as what was leaked. So as far as that is, oh, sorry, let me add this to the stream. There we go. Which is apparently substantively the same. If it's not, please do let me know. But I haven't read through, actually, I haven't had time to read through any of this stuff, really. Now, what happened is that Justice Thomas and Kavanaugh filed concurring opinions, and the Chief Justice filed an opinion concurring in the judgment. And so you have the controlling opinion, right? Which has 1, 2, 3, 4, 5 votes. So that's the concurring, so that's the controlling opinion, right? That's going to be considered the opinion of the court. Justice Thomas and Justice Kavanaugh filed concurring opinions, and so and Justice Roberts, this is going to be difficult, because what happens is courts interpret the decision based on the majority, right? Now you have three out of the 6 justices that voted for this writing concurring opinions, and apparently, especially since Roberts isn't, his opinion is concurring only in the judgment, and he didn't join the controlling opinion, right? So really, the vote was 5-1-3. What Thomas and Kavanaugh say is going to kind of limit the other courts are gonna. So maybe I should just read. On Twitter, there was a thread that made a lot of sense, that if I can find it, I will show it to you guys. So where is that? It's hard to believe all of this just happened so quickly. Okay, so this is Tommy Bennett, who is Associate Professor and Wall Family Fellow at Mizzou Law. And he seems to know his stuff. And he wrote this thread. Justice Kavanaugh's concurrence in Bruin is a perfect example of what Barry Friedman, some other professors, and I call a pivotal concurrence. And I think they're definitely right about this idea. What's that, you ask? Bruin was decided by a vote of 6-3. Importantly, all 6 members of the majority also signed on to the majority opinion. Now, he isn't talking about Dobbs versus Jackson. He's talking about another opinion that was 6-3. Okay? The general rule is that an opinion that garners the votes of a majority of the court is binding law. So we can ignore the concurrences, right? Not so fast. In our article, we identify a special kind of concurrence that has outsized importance, even though the formal voting rules say it has no force of law. We call this a pivotal concurrence, and there's surprisingly common, surprisingly common several per term. And honestly, a dissent is also not really just meaningless, right? A dissent does matter and does get cited. But these concurrences, because they are part of the votes that made it possible for the majority to exist, right? That makes them far more likely to be cited, especially as when they say, oh, well, I only joined because A, B, and C, then other lower courts are going to say, well, since only 4 of the justices signed on to the rest of that, that's going to help limit exactly where the lower courts go with this decision. I mean, one of the most important things I think is going to come out of this is a lot of people are going to start understanding that Supreme Court justice decisions aren't what people think. They really aren't. What this decision, so there's a lot of people who are going to think that this suddenly means that abortion is illegal everywhere in the country, or that Roe made it legal in every instance, right? That's not what happened. That's not how the Supreme Court works. And part of the reason Roe was such a bad decision, and Justice Rehnquist was just, I believe it was Rehnquist who wrote a dissent at the time. And later, many justices, including Ruth Bader Ginsburg, actually said this. The politicization of the courts that existed over pro-life, pro-choice, and the courts deciding that was actually the biggest problem, really. And it was the reason why a lot of people, including me, who, I mean, I don't think of myself as pro-choice or pro-life. I think both sides tend to be pretty extreme and very politicized. And I know a majority of Americans are somewhere in between this stuff, right? If you had a prohibition on the first trimester, if you allowed abortion on the first trimester and disallowed it in the third trimester and allowed states to decide in the second trimester, which was in some aspects the attempt of the Supreme Court in Roe. They tried to legislate that, and it just brought the court into a political position that it really should not have been in. And this reversal of Roe, which I am very happy about. By the way, if anybody watching wants to come on the stream and discuss this, please do. If you know me, just DM me and I'll send you a link. But what this is going to do is going to surprise a lot of people by not actually really affecting all that much, right? People in California are going. When I was in law school, I am not a lawyer. I did go to law school. When I was in law school, I went to this debate between a lawyer from the people at the American Way and lawyer at the Reason Foundation. And the debate was over Roe v. Wade, and the woman from the People for the American Way kept on talking about how there was danger that California would become, that abortion would become illegal in California. And during the Q&A, I'm like, come on, like, do you really seriously believe, like, let's say Roe v. Wade gets overturned, that it's going to that abortion is going to become illegal in California? And she was like, yeah, it will. And it was ridiculous. And so a lot of people actually believe that this, and this is on both sides, is going to suddenly going to change abortion laws in California and New York. This is not going to affect abortion laws in California and New York at all. What it will do is, apparently there are 13 states who have trigger laws. Those laws Technically, maybe you could say it's possible that at various attorney generals, I think I read something about the attorney general in Florida um, saying that, he's going to start enforcing. Apparently, Florida had some sort of trigger law. Um, I think it's possible attorney generals are going to claim to start enforcing trigger laws as soon as Monday, maybe. I mean, I guess they could declare that they're going to do it today. But no court. I mean, this is going to have to get go through the various courts. There's going to be all kinds of injunctions. There's going to be all kinds of lower court questions and decisions. You have to realize that state constitutions might be interpreted to give the exact same type of legal protections that Roe v. Wade tried to do under the federal constitution. So yeah, I think there's a lot of people who are going to be very, very shocked, especially the people who are most politically invested in Roe v. Wade. I think a lot of them are going to have a wake-up call when they realize, the overturning of Roe doesn't mean all of the stuff that we said. So what's going to happen with these concurrences is that they're going to end up limiting they're going to end up limiting the sorry sorry exactly the holding, how far this goes. So to some extent, I mean, I guess maybe the best thing to do is actually to read the concurrences and the dissent. So let's I believe, well, okay, so the syllabus is not actual law, but it really does explain things pretty well because it is written by, so here. Note, where it is feasible, a syllabus headnote will be released as is being done in connection with this case. At the time the opinion is issued, the syllabus constitutes no part of the opinion of the court, but has been prepared by the reporter of decisions for the convenience of the reader. Okay, so this is the syllabus. The case was argued December 1st, 2021, was decided today, June 24th, 2022. Mississippi's Gestational Age Act provides that except in a medical emergency or in case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. Mississippi Annotated Code, Respondents, Jackson Women's Health Organization, an abortion clinic, and one of its doctors challenged the act in federal district court, alleging that it violated this court's precedents establishing a constitutional right to abortion, in particular Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania versus Casey. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that Mississippi's 15-week restriction on abortion violates the court's cases forbidding states to ban abortion pre-viability. The Fifth Circuit affirmed, before this court, petitioners defend the act on the grounds that Roe and Casey were wrongly decided and that the act is constitutional because it satisfies rational basis review. The Constitution does not confer held, so this is the holding of the case, and usually the syllabus tracks very closely to the actual language used in the controlling opinion. The Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. The critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely on this basis of stare decisis. That's the basis of precedent. A proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe was based. The court therefore turns to the question that the Casey plurality did not consider. First, the court reviews whether the standard that the court's cases have used to determine whether the 14th Amendment reference to liberty protects a particular right. Okay, so you have to understand, the federal Constitution only applies to the federal government. The 14th Amendment makes it illegal for states to violate people's liberties without due process. And the interpretation of the Supreme Court, which I, like Justice Thomas, disagree with, is that the Liberty Clause incorporates the rights in the Bill of Rights, and not all of them in. It's a very confused and incoherent way of doing it, but it is how we do it. And that's what you're going to see Justice Thomas is going to, he's going to advocate that this whole framework be overturned. And frankly, I think he's right. I think this goes back to the civil rights cases, and that's the name of a particular case. There were 5 cases that were in the 1860s or maybe 1870, right after the Civil War. The Supreme Court decided 5 cases that they combined together and called the civil rights cases. So that's the name of the case. I'm talking about those particular cases that were decided by the Supreme Court. They limited the 14th Amendment in certain ways, and Justice Harlan dissented on them. He was known as the Great Dissenter, and honestly, I think his dissent was right, and the civil rights cases should be overturned. But because of the limitations that the civil rights cases put on the 14th Amendment, later courts found this substantive due process stuff in another clause of the 14th Amendment. And so all of this bad stare decisis, I would say, has caused a lot of confusion over the past 150 years. And so to some extent, this is a question of the 14th Amendment, right? Because there's one question, which is, does the federal Constitution guarantee abortion? So let's say you live in Washington, D.C., right? And let's say Congress had made abortion illegal in Washington, D.C., right? So that's a federal question. It's under the federal law. It's a law passed by Congress because Congress is what governs Washington, D.C., right? And so the first question becomes, well, does the Constitution allow Congress to do that, right? And the court was like, no. The federal Constitution does not allow that. That's the first bit. And the second bit is that through the 14th Amendment, this prohibition, this right to an abortion, also applies to the state governments. Okay? So this is a two-part thing there. And that's why first they're going to start on the 14th Amendment thing, which asks, is this something that's incorporated by the 14th Amendment from the federal Constitution into the state constitution? And then we'll keep on going. But the Constitution makes no express reference to a right to obtain an abortion, but several Constitution provisions have been offered as potential homes for an implicit constitutional right. Roe held that the abortion right is part of a right to privacy that springs from the First, Fourth, Fifth, Ninth, and 14th Amendments. The Casey court grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's Due Process Clause. Others have suggested that support can be found in the 14th Amendment's Equal Protection Clause, but that theory is squarely foreclosed by the court's precedents, which establish that a state's regulation of abortion is not a sex-based classification and thus not subject to the heightened scrutiny that applies to such classifications. Rather, regulations and prohibitions of abortion are governed by the same standard of review as other health and safety measures. Next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of ordered liberty. So this is the standard by which things are incorporated by the 14th Amendment from the federal Constitution onto the states. The court finds that the right to abortion is not deeply rooted in the nation's history and tradition. The underlying theory on which Casey rested, that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for liberty, has long been controversial. Oh, duh. My brain was. I was wondering why yesterday I was retweeting things about the Supreme Court, and I just remembered, yesterday's Supreme Court opinion was also a one that liberals lost their mind. That was the gun one, right? So now this is the abortion one. Yeah, I mean, all of this stuff applies. See, that's the thing. The gun stuff that is explicit in the state, in the federal Constitution, and oftentimes the gun laws we are talking about are even federal gun laws, right? There aren't really federal abortion laws, even though there are a lot of Democrats who are talking about having federal abortion laws now. Yeah. I'm sorry if this is all over the place, because I don't know what people are interested in talking about. Please do comment. Oh, there we go. We have a comment. I think the main effect is that it um, it gives people tacit permission to make appeals to authority in social situations. Yeah, that's yeah, yeah. You're right. When you're right, you're right. That's why we have such weird discussions. Honestly, it bothers me a lot that the perception of the Supreme Court is so far off from the reality of the Supreme Court. So on my server, we I'm gonna see if Father Big Mac wants to come on. On my server, we were having a discussion, and it was actually about something else. Okay, he does not. Okay, I guess just to clarify how courts work. A court of primary jurisdiction holds so yeah, people were talking about the role people were talking about the role of so yeah, Father Big Mac, as a priest, has only the opinion that that the Catholic Church is opposed to abortions, which is the Catholic opinion, and he doesn't really want to go past that, which is a perfectly sane thing for a pastor to say. So people have a completely unreal and what the Supreme Court actually does is nothing like what most people think it does. And on my server, we had this whole discussion because people thought that the Supreme Court is views evidence, and it's like, no, never. Like, pretty much never. The Supreme Court doesn't look at evidence at all, and that's actually part of what I read as part of Kavanaugh's, I believe it was Kavanaugh's concurrence. Oh no, it was I forget whose it might have been Alito's concurrence yesterday on the gun decision. Yeah, people make a lot of, I don't know what to tell you. I don't know what to tell you. Okay, let's go back to this. The court finds that the right to abortion is not deeply rooted in the nation's history and tradition. The underlying theory on which Casey rested, that the 14th Amendment's due process clause provides substantive as well as procedural protection for liberty, has long been controversial. The court's decisions have held that the due process clause protects two categories of substantive rights: those rights guaranteed by the first 8 amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in the Constitution. So this is part of what I don't like, is a lot of things that really should be based in the 9th and 10th Amendments are have been written into the 14th Amendment, and because there are Supreme Court decisions deciding that the 9th and 10th Amendments basically say nothing. There are no legal ramifications of the 9th and 10th Amendments according to the Supreme Court, which is ridiculous in my opinion. Yeah. The term liberty alone provides little guidance. Thus, historical inquiries are essential whenever the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution. Guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, the court finds the 14th Amendment clearly does not protect the right to an abortion. Under the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treatise. Indeed, abortion has long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Respondents' arguments that this history does not matter flies in the face of the standard the court has applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. And this is a whole thing that they get into. But the great common law authorities, Bracton, Coke, Hale, and Blackstone, all wrote that a post-quickening abortion was a crime. Moreover, many authorities asserted that even a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder if the woman died from the attempt. The Solicitor General suggests that history supports an abortion right because of the common law's failure to criminalize abortion before quickening, but the insistence on quickening was not universal. And regardless, the fact that many states in the late 18th and early 19th century did not criminalize quickening abortion does not mean that anyone thought the states lacked the authority to do so. Instead of seriously pressing the argument that the abortion right has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Roe termed this a right to privacy, and Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. Ordered liberty sets limits and defines the boundaries between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. but the people of the various states may evaluate those interests differently. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. 3. Finally, the court considers whether a right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. The court concludes the right to obtain an abortion cannot be justified as a component of such a right. Attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged. Abortion is different because it destroys what Roe termed potential life. And what the law challenged in this case calls an unborn human being. None of the other decisions cited by Roe and Casey involved the critical moral question posed by abortion. Accordingly, those cases do not support the right to obtain an abortion, and the court's conclusion that the Constitution does not confer such a right does not undermine them in any way. B. The doctrine of stare decisis does not counsel continued acceptance of Roe and Casey. Stare decisis plays an important role and protects the interests of those who have taken action in reliance on a past decision. It reduces incentives for challenging settled precedents, saving parties and courts the expenses of endless relitigation. It contributes to the actual and perceived integrity of the judicial process, and it restrains judicial hubris by respecting the judgment of those who grappled with important questions in the past. But stare decisis is not an inexorable command, and as it is at its weakest when the court interprets the Constitution. Some of the court's most important constitutional decisions have overruled prior precedents. See Brown versus Board of Education and overruling Plessy versus Ferguson. The court's cases have identified factors that should be considered in deciding when a precedent should be overruled. 5 factors discussed below weigh strongly in favor of overruling Roe and Casey. The nature of the court's error, like the infamous decision in Plessy versus Ferguson, Roe was also egregiously wrong and on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors, calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who disagreed with Roe. 2. The quality of the reasoning. Without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy, divided into trimesters, much like those that one might expect to find in a statute or regulation. And really, that's what was going on is people tend, I would say a majority of people actually like most of Roe's trimester analysis, and that's why politicians cite it so much, even though it was overruled in Casey, because it's not workable as far as court cases. I think. I mean, this, even Ruth Bader Ginsburg agreed that this could have been resolved better if if the courts had stayed out of it. And that's what decision does. It takes the courts out of it. um, Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking, and what it said about the common law was simply wrong. Then, after surveying history, the opinion spent many paragraphs conducting the sort of fact finding that might be undertaken by a legislative committee, and did not explain why the sources on which it relied shed light on the meaning of the Constitution. Again, the Supreme Court is not supposed to be fact finding when considering the history of a law or the Constitution. They do engage in fact finding where relevant. But part of the reason, for example, the dissent in yesterday's case, part of the reason that the dissent was, the dissent was called out on their whole analysis was they keep on turning into the Supreme Court into a super legislature. And that's what the conservatives are trying to undo. They want to return this stuff, especially the controversial stuff, back to being political questions that the courts do not get involved in. And the fact that our Supreme Court nominations have been so politicized is because of decisions like Roe, right? And the hope is that when the decisions like this are no longer being made by the Supreme Court, there will be fewer people so politically invested in the Supreme Court, getting involved in this stuff. Okay, if you guys have any questions or stuff, I think this is kind of boring reading this stuff unless people are interested in it. Let me know. Comment. We have comments. Let's see here. Lance, who is a lawyer. I find Thomas's concurring opinion really interesting too, Jacob. He clearly wants to take up Griswold, Lawrence, and Obergefell and fix the erroneous case law in those cases. Yeah, I think honestly, the way we see the 14th Amendment, the way we see the 9th and 10th Amendments, there's a lot that is wrong that I want to see the Supreme Court revisit in real ways. But we need to get back to teaching civics in high school and the actual constitutional powers of the 3 states. People are lazy and want the Supreme Court to fix the failure of the other branches to do their jobs. I don't know if lazy is the word there. Certainly, our education system is failing our students in many ways, including civics. But honestly, they're failing to teach reading and writing. And when you do that, how do you expect people to come out of it in civics? Okay, I am going to take a short break. If anybody wants to come on, including Lance, please let me know. If there's anything you guys want to talk about, let me know. I think instead of redoing, because it really seems like, yeah, it this is, to me, it seems it's pretty clear that it's just a rehash of the stuff that it is the same opinion that was leaked. I am interested in seeing Thomas and Kavanaugh's concurring opinions, and then reading the dissenting opinions and seeing where that goes. So I am going to do a 2-minute break, in which time people can decide if they want to, if they have questions, if they want to make comments, if they want to come on or not. Um, okay. So on page 117, this is Thomas's concurring opinion. So the majority opinion was agreed to by 5 people, right? And Thomas and Kavanaugh were part of those 5 people. So their opinion is going to help shape how courts interpret the majority opinion, because without their votes, then the court's opinion wouldn't have won the day. Now, this gets a tiny bit complicated by the fact that the Chief Justice was concurring in the ruling, but not in the reasoning. And I'm actually wondering if I'm going to agree with his reasoning more. Partially because if it was me, I probably would have overturned Casey and hinted at overturning Roe later. But I also understand wanting to just rip the bandage off all at once. So let's see. Justice Thomas concurring. I join the opinion of the court because it correctly holds that there is no constitutional right to abortion. Respondents invoke one source for that right. The 14th Amendment's guarantee that no state shall deprive any person of law, life, liberty, or property without due process of law. The court well explains why, under our substantive due process precedents, the purported right to abortion is not a form of liberty protected by the Due Process Clause. Such a right is neither deeply rooted in this nation's history and tradition, nor implicit in the concept of ordered liberty. The idea that the framers of the 14th Amendment understood the Due Process Clause to protect a right to abortion is farcical. And he's citing his own dissent. I write separately to emphasize a second, more fundamental reason why there is no abortion guarantee lurking in the Due Process Clause. Considerable historical evidence indicates that a due process of law merely required executive and judicial actors to comply with legislative enactments and the common law when depriving a person of life, liberty, or property. And he's citing himself. Other sources, by contrast, suggest that due process of law prohibited legislatures from authorizing the deprivation of a person's life, liberty, or property without providing him the customary procedures to which freemen were entitled by the old law of England. So this is his alternative reading of the 14th Amendment to basically how the Supreme Court has been treating it for a very long time. So he wants to completely change the game, and I have to agree with him. I mean, none of the other Supreme Court justices have at all indicated that they're interested in this type of analysis, and yeah, Lance can't come on. So he's really writing this. So he has an army of judges who were his clerks. I think part of it is he's writing this in order to for much further posterity. I don't think he thinks this is going to currently, but this is one of his hobby horses. Which I agree with, but it's nothing that's going to be that's going to come to fruition even within the next, I don't know, 30 years. at least not until a justice comes on the Supreme Court who's willing to even consider these things that he's saying. I hope one eventually does, but we have 6 conservative justices right now, and Thomas is the only one willing to do this type of analysis. As I have previously explained, substantive due process is an oxymoron that lacks any basis in the Constitution. Right. Text and history provide little support for modern substantive due process doctrine. The notion that a constitutional provision that guarantees only process before a person is deprived of life, liberty, or property could define the substance of those rights strains credulity for even the most casual users of the word of words. He's right. Apparently, Scalia wrote something similar in 1994. Obviously, Scalia is no longer on the Supreme Court. The resolution of this case is thus straightforward. Because the due process clause does not secure any substantive rights, it does not secure a right to abortion. The court today declines to disturb substantive due process jurisprudence generally or the doctrine's application in other specific cases, contexts. Cases like Griswold, Lawrence, and Obergefell are not at issue. The court's abortion cases are unique, and no party has asked us to decide whether our entire 14th Amendment jurisprudence must be preserved or revised. Thus, I agree that nothing in the court's opinion should be understood to cast doubt on precedents that do not concern abortion. It's funny, but apparently, so this, I was seeing on Twitter people interpreting this as him directly threatening those cases, and like he's saying, it does not, and he makes it really clear. For that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell, because any substantive due process decision is demonstrably erroneous. He at least wants people to make this argument, and I'm guessing this argument isn't even being made in Amici stuff. Yeah, after overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are privileges or immunities of citizens of the United States protected by the 14th Amendment. And this, I mean, this is very radical stuff, which I agree with completely. But I don't see anybody even discussing this stuff other than Thomas. To answer that question, we would need to decide important antecedent questions, including whether the Privileges or Immunities Clause protects any rights that are not enumerated in the Constitution, and if so, how to identify those rights. That said, even if the clause does protect unenumerated rights, the court conclusively demonstrates that abortion is not one of them under any plausible interpretive approach. Moreover, apart from being a demonstrably incorrect reading of the Due Process Clause, the legal fiction of substantive due process is particularly dangerous. I think he's right. At least 3 dangers favor jettisoning the doctrine entirely. First, substantive due process exalts judges at the expense of the people from whom they derive their authority. Because the Due Process Clause speaks only to process, the court has long struggled to define what substantive rights it protects. In practice, the court's approach for identifying those fundamental rights unquestionably involves policymaking rather than neutral legal analysis. I mean, I agree with him. The court divines new rights in line with its own extra constitutional value preferences and nullifies state laws that do not align with the judicially created guarantees. Nowhere is this exaltation of judicial policymaking clearer than this court's abortion jurisprudence. In Roe, the court divined a right to abortion because it felt that the 14th Amendment's concept of personal liberty includes a right of privacy that is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. In Casey, the court likewise identified an abortion guarantee in the liberty protected by the 14th Amendment, but rather than a right of privacy, sorry, there's an ambulance going by. It invoked an ethereal right to define one's own concept of existence, of meaning of the universe, and of the mystery of human life. As the court's preferred manifestation of liberty changed, so too did the test used to protect it, as Roe's authors lamented. The Roe framework is far more administrable and far less manipulable than the undue burden standard. Now, in this case, the nature of the purported liberty supporting the abortion right has shifted yet again. Respondents and the United States propose no fewer than 3 different interests that supposedly spring from the Due Process Clause. They include bodily integrity, personal autonomy in matters of family, medical care, and faith, and women's equal citizenship. That 50 years have passed since Roe, and abortion advocates still cannot coherently articulate the right or rights at stake proves the obvious. The right to abortion is ultimately a policy goal in desperate search of a constitutional justification. Second, substantive due process distorts other areas of constitutional law. He's right. For example, once this court identifies a fundamental right for one class of individuals, it invokes the Equal Protection Clause to demand exacting scrutiny of statutes that deny the right to others. Eisenstadt, relying on Griswold to invalidate a state statute prohibiting distribution of contraceptives to unmarried persons. Wow, this is 1972. I see. Statutory classifications implicating certain non-fundamental rights, meanwhile, receive only cursory review. Similarly, this court deems unconstitutionally vague or overbroad those laws that impinge on its preferred rights, while letting slide those laws that implicate supposedly lesser values. And again, he's citing himself. In fact, our vagueness doctrine serves as the basis for the first draft of the majority opinion in Roe v. Wade, and it since has been deployed to nullify even mild regulations of the abortion industry. Therefore, regardless of the doctrinal context, the court often demands extra justification for encroachments on preferred rights while relaxing purportedly higher standards for review for lesser preferred rights. And again, this kind of goes back to the gun issue. Substantive due process is the core inspiration for many of the court's constitutionally unmoored policy judgments. Third, substantive due process is often wielded to disastrous ends. Again, citing himself, for instance, in Dred Scott versus Sanford, 1857. Really? This was substantive. The court invoked a species of substantive due process to announce that Congress was powerless to emancipate slaves brought into the federal territories. I have to wonder about that. Was Dred Scott a species of substantive due process? While Dred Scott was overruled on the battlefields of the Civil War and by constitutional amendment after Appomattox, that overruling was purchased at the price of immeasurable human suffering. Now today, the court rightly overrules Roe and Casey, two of the court's most notoriously incorrect substantive due process decisions. After more than 63 million abortions have been performed, the harm caused by this court's forays into substantive due process remains immeasurable. Yeah, they're not going to like that. Because the court properly applies our substantive due process at precedents to reject the fabrication of a constitutional right to abortion, and because this case does not present the opportunity to reject substantive due process entirely, I join the court's opinion. But in future cases, we should follow the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds beyond that a right to due process when life, liberty, or property is to be taken away. Opinion of Scalia. Honestly, I don't recall reading Scalia's opinions being so stridently anti substantive due process, but apparently he was. None of the other courts, nobody joined Thomas's opinion here. Substantive due process conflicts with the textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. Again, I agree with him. I think the earliest opportunity is at least 50 years away. Okay. So this is Kavanaugh's concurrence. And apparently he tried to limit the decision more. So let's see. I write separately to explain my additional views about why Roe was wrongly decided, why Roe should be overruled at this time, and the future implications of today's decisions. So that last part is actually what's going to really matter. Abortion is a profoundly difficult and contentious issue because it presents an irreconcilable conflict between the interests of a pregnant woman who seeks an abortion and the interests of protecting fetal life. The interests on both sides of the abortion issue are extraordinarily weighty. On the one side, many pro-choice advocates forcefully argue that the ability to obtain an abortion is critically important for women's personal and professional lives and for women's health. They contend that the widespread availability of abortion has been essential for women to advance in society and to achieve greater equality over the last 50 years. And they maintain that women must have the freedom to choose for themselves whether to have an abortion. On the other side, many pro-life advocates forcefully argue that a fetus is a human life. They contend that all human life should be protected as a matter of human dignity and fundamental morality. And they stress that a significant percentage of Americans with pro-life views are women. When it comes to abortion, one interest must prevail over the others at any given point in a pregnancy. Many Americans of good faith would prioritize the interests of the pregnant woman. Many other Americans of good faith instead would prioritize the interests of in protecting fetal life. At least unless, for example, an abortion is necessary to save the life of the mother. Of course, many Americans are conflicted or have nuanced views that may vary depending on the particular time in a pregnancy or the particular circumstances of a pregnancy. The issue before this court, however, is not the policy or morality of abortion. The issue before the court is what the Constitution says about abortion. The Constitution does not take sides on the issue of abortion. The text of the Constitution does not refer to or encompass abortion. To be sure, this court has held that the Constitution protects unenumerated rights that are deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. But a right to abortion is not deeply rooted in American history and tradition, as the court today thoroughly explains. Not gonna read the note. On the Constitution, on the question of abortion, the Constitution is therefore neither pro-life nor pro-choice. The Constitution is neutral and leaves the issue for the people and their elected representatives to resolve through the democratic process in the states or Congress. That's interesting, or Congress. Like the numerous other difficult questions of American social and economic policy that the Constitution does not address. Because the Constitution is neutral on the issue of abortion, this court must also be scrupulously neutral. The 9 unelected members of this court do not possess the constitutional authority to override the democratic process and to decree either a pro-life or pro-choice abortion policy for all 330 million people in the United States. Instead of adhering to the Constitution's neutrality, the court in Roe took sides on the issue and unilaterally decreed that abortion was legal throughout the United States up to the point of viability, about 24 weeks of pregnancy. The court's decision today properly returns the court to a position of neutrality and restores the people's authority to address the issue of abortion through the processes of democratic self-government established by the Constitution. Some amicus briefs argue that the court today should not only overrule Roe and return to a position of judicial neutrality on abortion, but should go further and hold that the Constitution outlaws abortion throughout the United States. No justice of this court has ever advanced that position. I respect those who advocate for that position, just as I respect those who argue that this court should hold that the Constitution legalizes pre-viability abortion throughout the United States. But both positions are wrong as a constitutional matter, in my view. And basically, so he's actually explaining what this court really is doing, but I doubt very much most people are going to listen to him. So, yeah. The Constitution neither outlaws abortion nor legalizes abortion. And it's funny that he's the one who they wanted to murder. To be clear, then, the court's decision today does not outlaw abortion throughout the United States. On the contrary, the court's decision properly leaves the question of abortion for the people and their elected representatives in the democratic process. Through that democratic process, the people and their representatives may decide to allow or limit abortion. As Justice Scalia stated, the states may, if they wish, permit abortion on demand, but the Constitution does not require them to do so. Today's decision, therefore, does not prevent the numerous states that readily allow abortion from continuing to readily allow abortion. That includes, if they choose, the amici states supporting the plaintiff in this court: New York, California, Illinois, By contrast, other states may maintain laws that more strictly limit abortion. After today's decision, all of the states may evaluate the competing interests and decide how to address this consequential issue. Yeah, I'm not going to read that note. In arguing for a constitutional right to abortion that would override the people's choices in the democratic process, the plaintiff, Jackson Women's Health Organization, and its amici emphasize that the Constitution does not freeze the American people's rights as of 1791 or 1868. I fully agree. To begin, I agree that constitutional rights apply to situations that were unforeseen in 1791 or 1868, such as applying the First Amendment to the internet or the 14th Amendment to cars. Moreover, the Constitution authorizes the creation of new rights, state and federal, statutory, and constitutional. But when it comes to creating new rights, the Constitution directs the people to the various processes of democratic self-government contemplated by the Constitution, state legislation, state constitutional amendments, federal legislation, and federal constitutional amendments. See generally the amendments. Okay. The Constitution does not grant the 9 unelected members of this court the unilateral ability to rewrite the Constitution to create new rights and liberties based on our own moral or policy views. As Justice Rehnquist stated, this court has not been granted a roving commission either by the Founding Fathers or by the framers of the 14th Amendment to strike down laws that are based upon notions of policy or morality suddenly found unacceptable by a majority of this court. This court, therefore, does not possess the authority either to declare a constitutional right to abortion or to declare a constitutional prohibition of abortion. Can't really imagine what even the argument is for a constitutional prohibition of abortion. Oh, okay, yeah, I can. That the baby has a right to life. Nobody's going to go there, I don't think. In sum, the Constitution is neutral on the issue of abortion. Although, honestly, if the right wanted to kind of recenter the debate, they could have, maybe they should be advocating for something like that. Because unfortunately, too many people are radical centrists, and their whole idea is, well, let me look at the 2 opposing sides and find a position in the middle. And I think that's a lot of what the left has been doing in deranging our conversation, is taking ridiculous positions and advocating that people take some sort of middle route there. In sum, the Constitution is neutral on the issue of abortion and allows the people and their elected representatives to address the issue through the democratic process. In my respectful view, the court in Roe therefore erred by taking sides on the issue of abortion. The more difficult question in this case is stare decisis, that is, whether to overrule the Roe decision. The principle of stare decisis requires respect for the court's precedents and for the accumulated wisdom of the judges who have previously addressed the same issue. Stare decisis is rooted in the Article 3 of the Constitution and is fundamental to the American judicial system and to the stability of American law. Adherence to precedent is the norm, and stare decisis imposes a high bar before this court may overrule a precedent. This court's history shows, however, that stare decisis is not absolute and indeed cannot be absolute. Otherwise, as the court today explains, many long since overruled cases such as Plessy, Lochner, Minersville School, and Bowers versus Hardwig, which I was very surprised to see that overruled in Lawrence so quickly, but would never have been overruled and would still be the law. In his canonical Burnett opinion in 1932, Justice Brandeis stated that in cases involving the federal Constitution where correction through legislative action is practically impossible, this court has often overruled its earlier decisions. That description of the court's practice remains accurate today. Every current member of the court has voted to overrule precedent, and over the last 100 years, beginning with Chief Justice Taft's appointment in 1921, every one of the 48 justices appointed to this court has voted to overrule precedent. Many of these justices have voted to overrule a substantial number of very significant and long-standing precedents. See Obergefell, Brown versus Board of Education, West Coast Hotel versus Parrish. I forget what that was about. And in fact, Lochner versus New York. But what history alone does not answer, but that history alone does not answer the critical question: when precisely should the court overrule an erroneous constitutional precedent? The history of stare decisis in this court establishes that a constitutional precedent may be overruled only when, one, the prior decision is not just wrong, but is egregiously wrong. And I don't really understand like how you make that difference and how you, I mean, the most obvious egregiously wrong opinion was Korematsu, to the point where the court just mentioned that it was ab initio bad law, and just to formally mention that, okay, we all realized this was horrible and it's not law, right? Yeah, Korematsu was something else. The prior decision has caused significant negative jurisprudential or real world consequences. Okay. And 3, overruling the prior decision would not unduly upset legitimate reliance interests. I don't see how this is a good test. I really don't. Applying those factors, I agree with the court today that Roe should be overruled. The court in Roe erroneously assigned itself the authority to decide a critically important moral and policy issue that the Constitution does not grant this court the authority to decide. As Justice Byron White succinctly explained, Roe was an improvident and extravagant exercise of the power of judicial review, because nothing in the language or history of the Constitution supports a constitutional right to abortion. Of course, the fact that a precedent is wrong, even egregiously wrong, does not alone mean that the precedent should be overruled. But as the court today explains, Roe has caused significant negative jurisprudential and real-world consequences. By taking sides on a difficult and contentious issue on which the Constitution is neutral, Roe overreached and exceeded this court's constitutional authority, gravely distorted the nation's understanding of the court's proper constitutional role. You can say that again many, many times, and caused significant harm to what Roe itself recognized as the state's important and legitimate interest in protecting fetal life. All of that explains why tens of millions of Americans and the 26 states that explicitly asked the court to overrule Roe do not accept Roe even 49 years later. Under the court's long-standing stare decisis principles, Roe should be overruled. But the stare decisis analysis here is somewhat more complicated because of Casey. In 1992, 19 years after Roe, Casey acknowledged the continuing dispute over Roe. The court sought to find common ground that would resolve the abortion debate and the national controversy. After careful and thoughtful consideration, the Casey plurality reaffirmed a right to abortion through viability, about 24 weeks, while also allowing somewhat more regulation of abortion than Roe had allowed. I have deep and unyielding respect for the justices who wrote that the Casey plurality opinion, and I respect the Casey plurality's good faith effort to locate some middle ground or compromise that could resolve this controversy for America. But as has become increasingly evident over time, Casey's well-intentioned effort did not resolve the abortion debate. The national division has not ended. In recent years, a significant number of states have enacted abortion restrictions that directly conflict with Roe. Those laws cannot be dismissed as political stunts or as outlier laws. Those numerous state laws collectively represent the sincere and deeply held view of tens of millions of Americans who continue to fervently believe that allowing abortion up to 24 weeks is far too radical and far too extreme and does not sufficiently account for what Roe itself recognized as the state's important and legitimate interest in protecting fetal life. In this case, moreover, a majority of the states, 26 in all, ask the court to overrule Roe and return the abortion issue to the states. In short, Casey's stare decisis analysis rested in part on a predictive judgment about the future development of state laws and of the people's views on the abortion issue, but that predictive judgment has not borne out. And as the court today explains, the experience over the last 30 years conflicts with Casey's predictive judgment and therefore undermines Casey's presidential force. So I will read this. To be clear, public opposition to a prior decision is not a basis for overruling or reaffirming that decision. Rather, the question of whether to overrule a precedent must be analyzed under this court's traditional stare decisis factors. I disagree with him. I think really, when you say egregiously wrong, all you're saying is that it has in fact been incredibly divisive and thing. The only point here is that Casey adopted a special stare decisis principle with respect to Roe based on the idea of resolving the national controversy and ending the national division over abortion. The continued and significant opposition to Roe, as reflected in the laws and positions of numerous states, is relevant to assessing Casey in its own terms. In any event, although Casey is relevant to the stare decisis analysis, the question of whether to overrule Roe cannot be dictated by Casey alone. To illustrate that stare decisis point, consider an example. Suppose that in 1924, this court had expressly reaffirmed Plessy versus Ferguson and upheld the state's authority to segregate people on the basis of race. With the court in Brown some 30 years later, in 1954, have reaffirmed Plessy and upheld racially segregated schools simply because of that intervening 1924 precedent? Surely the answer is no. In sum, I agree with the court's application today of the principles of stare decisis and its conclusion that Roe should be overruled. Again, I would have argued overrule Casey while keeping Roe for now. After today's decisions, the 9 members of this court will no longer decide the basic legality of pre-viability abortion for all 330 million Americans. That issue will be resolved by the people and their representatives in the democratic process in the states or Congress. But the parties' arguments have raised other related questions, and I address some of them here. First is the question of how this decision will affect other precedents involving issues such as contraception and marriage, in particular the decisions in Griswold, Eisenstadt, Loving. To throw Loving in here, it's amazing. Obergefell. There is no question. You could overrule Loving today and it would have zero effect because nobody's interested. Well, let me correct myself. Only the extreme left is interested in prohibiting interracial marriage. I emphasize that the court today states overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents. Second, as I see it, some of the other abortion-related legal questions raised by today's decisions are not especially difficult as a constitutional matter. For example, may a state bar a resident of that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel. May a state retroactively impose liability or punishment for an abortion that occurred before today's decision takes effect? In my view, the answer is no, based on the due process clause or the ex facto clause. Other abortion-related legal questions may emerge in the future, but this court will no longer decide the fundamental question of whether abortion must be allowed throughout the United States through 6 weeks or 12 weeks or 15 weeks or 24 weeks or some other line. The court will no longer decide how to evaluate the interests of the pregnant woman and the interests in protecting fetal life throughout pregnancy. Instead, those difficult moral and policy questions will be decided, as the Constitution dictates, by the people and their elected representatives through the constitutional processes of democratic self-government. The Roe Court took sides on a constitutional, moral, and policy issue that this court had no constitutional authority to decide. By taking sides, the Roe Court distorted the nation's understanding of this court's proper role in the American constitutional system and thereby damaged the court as an institution. As Justice Scalia explained, Roe destroyed the compromises of the past, rendered compromise impossible for the future, and required the entire issue to be resolved uniformly at the national level. Just seeing if anybody else has comments, please. I mean, this is a live broadcast, a live stream. If you are interested in coming on and discussing this, please DM me. If you have comments, please do put them in the chat. The court's decision today properly returns the court to a position of judicial neutrality on the issue of abortion and properly restores the people's authority to resolve the issue of abortion through the processes of democratic self-government established by the Constitution. To be sure, many Americans will disagree with the court's decision today. That would be true no matter how the court decided this case. Both sides of the abortion issue believe sincerely and passionately in the rightness of their cause. Especially in those difficult and fraught circumstances, the court must scrupulously adhere to the Constitution's neutral position on the issue of abortion. Since 1973, more than 20 justices of this court have now grappled with the divisive issue of abortion. I greatly respect all of the justices, past and present, who have done so amidst extraordinary controversy and challenges. All of them have addressed the abortion issue in good faith after careful deliberation and based on their sincere understanding of the Constitution and of precedent. I have endeavored to do the same. In my judgment on the issue of abortion, the Constitution is neither pro-life nor pro-choice. The Constitution is neutral. And this court likewise must be scrupulously neutral. The court today properly heeds the constitutional principle of judicial neutrality and returns the issue of abortion to the people and their elected representatives in the democratic process. I'm going to make this a little bit bigger. Okay, now for the dissent. Let's see. Oh no, so Justice Roberts did not sign on with the majority opinion. So let's see what he says. Concurring in the judgment. We granted certiorari to decide one question: whether all pre-viability prohibitions on elective abortion are unconstitutional. That question is directly implicated here. Mississippi's Gestational Act generally prohibits abortion after the 15th week of pregnancy, several weeks before a fetus is regarded as viable outside the womb. I'm wondering why that comment from which hasn't come on to the stream here. Maybe it's just taking time. Yeah, I have a lot more Twitch viewers than I have now. So I had a comment which isn't coming through like it should, so I can't put it on the screen. Says Aqua USA GI says I am pro-choice. That doesn't tell me much about the thing. Generally prohibits several weeks before a fetus is regarded as viable outside the womb. In urging our review, Mississippi states that its case was an ideal vehicle to reconsider the bright line viability rule, and that a judgment in its favor would not require the court to overturn Roe and Casey. Today, the court nonetheless rules for Mississippi by doing just that. I would take a more measured course. I agree with the court that the viability line established by Roe and Casey should be discarded under a straightforward stare decisis analysis. That line never made any sense. Our abortion precedents describe the right at issue as a woman's right to choose to terminate her pregnancy. That right should therefore extend far enough to ensure a reasonable opportunity to choose, but need not extend any further. Certainly not all the way to viability. Mississippi's law allows a woman 3 months to obtain an abortion, well beyond the point at which it is considered late to discover a pregnancy. So now he's okay. So his line is now whether or not she knows she's pregnant, and so how much time does she get to make that decision? I see no sound basis for questioning the adequacy of that opportunity, but that is all I would say out of adherence to a simple yet fundamental principle of judicial restraint. If it is not necessary to decide more to dispose of a case, then it is not necessary. Then it is necessary not to decide more. Perhaps we are not always perfect in following that command, and certainly there are cases that warrant an exception. But this is not one of them. Surely we should adhere closely to principles of judicial restraint here, where the broader path the court chooses entails repudiating a constitutional right we have not only previously recognized, but also expressly reaffirmed, applying the doctrine of stare decisis. The court's opinion is thoughtful and thorough, but those virtues cannot compensate for the fact that it dramatically and consequential ruling is unnecessary to decide the case before us. What would be the point of overturning Casey but not Roe? It would just be inviting the exact case back at a later date. Yeah, it would. It would in fact be, but it would be precisely a step below what Roberts is saying here, which is to decide this case and leave both Casey and Roe. I think overturning, I think the court needs to move slowly, needs to signal where it's going. And so overturning one and inviting a later case, which would then further remove it, I think is a much better way of going about things. Let me begin with my agreement with the court on the only question we need decide here: whether to retain the rule from Roe and Casey that a woman's right to terminate her pregnancy extends up to the point that the fetus is regarded as viable outside the womb. I agree that this rule should be discarded. First, this court seriously erred in Roe in adopting viability as the earliest point at which a state may legislate to advance its substantial interests in the area of abortion. Roe set forth a rigid three-part framework anchored to viability, which more closely resembled a regulatory code than a body of constitutional law. That framework, moreover, came out of thin air. It's true. Neither the Texas statute challenged in Roe nor the Georgia statute at issue in its companion case included any gestational age limit. No party or amicus asked the court to adopt a bright line viability rule. And as for Casey, arguments for and or against the viability rule played only a de minimis role in the parties' briefing and in the oral arguments. It is thus hardly surprising that neither Roe nor Casey made a persuasive or even deliberate or colorable argument for why the time for terminating a pregnancy must extend to viability. The court's jurisprudence on this issue is a textbook illustration of the perils of deciding a question neither presented nor briefed. As has been often noted, Roe's defense of the line boiled down to the circular assertion that the state's interest in compelling only when an unborn child can live outside the womb, because that is when the unborn child can live outside the womb. Okay. Rose recently mistakes a definition for syllogism. Okay, I mean, whatever. 20 years later, the best defense of the viability line the Casey plurality could conjure up was workability. Discussing the difficulties, although the plurality attempted to add more content by opining that it might be said that a woman who fails to act before viability has consented to the state's intervention on behalf of the developing child, that mere suggestion provides no basis for choosing viability as the critical tipping point. A similar implied consent argument could be made with respect to a law banning abortion after 15 weeks, well beyond the point at which nearly all women are aware that they are pregnant. Where is he getting this awareness argument from? This is the first I've heard of it. And anytime, I mean, these aren't, he's not even citing cases. He's the dissent, which would retain the viability line, offers no justification for it either. This court's jurisprudence since Casey, moreover, has eroded the underpinnings of the viability line, such as they were. The viability line is a relic of a time when we recognized only two state interests warranting regulation of abortion: maternal health and protection of potential life. That changed with Gonzalez. It did. There, we recognized a broader array of interests, such as drawing a bright line that clearly distinguishes abortion and infanticide, maintaining societal ethics, and preserving the integrity of the medical profession. The viability line has nothing to do with advancing such permissible goals. Ginsburg, dissenting, Gonzalez blurred the line firmly drawn in Casey between pre-viability and post-viability. Okay. Consider, for example, statutes passing in a number of jurisdictions that forbid abortion after 20 weeks of pregnancy, premised on the theory that a fetus can feel pain at that stage of development. Assuming that prevention of fetal pain is a legitimate state interest after Gonzalez, there seems to be no reason why viability would be relevant to the permissibility of such laws. The same is true of laws designed to protect the integrity and ethics of the medical profession and restrict procedures. He wants to leave this in the courts, and it's just such a huge mistake. I don't even understand where he's coming from. Mississippi's law, for instance, was premised. I'm still wondering why that comment did not come through. let me reload, and hopefully this will fix that. Let's see. Okay, so now I have a bunch more comments, which I wasn't seeing before. Let me bring up my, well, let me, yay, Lance is back. Yep, Thomas is encouraging people to bring those cases. Trust me, now that he's signaled, he'll get some. He's been signaling this for a very long time. Whether they take them up, another question. Yeah, I doubt it. Fluffy was just able to tune in after work. Looking forward to hearing the whole thing later. Okay, it was nice for you to show up. That's Twitch chat still hasn't shown up. I don't know why, but at least I got these other chats. Let me see if there's. Oh wow, there's a lot of. Oh no, this is a different thing. Sorry. Guess I'm not gonna get. Okay. Okay. Sorry about this, guys. Let me bring my screen back up. Okay. The same is true of laws designed to protect the integrity and ethics of the medical profession and restrict procedures likely to coarsen society to the dignity of human life. Mississippi's law, for instance, was premised in part on the legislature's finding that the dilation and evacuation procedure that's partial birth is a barbaric practice, dangerous for the maternal patient and demeaning to the medical profession. That procedure accounts for most abortions performed after the first trimester, 2 weeks before the period at issue in this case, and involves the use of surgical instruments to crush and tear the unborn child apart. Again, it would make a little sense to focus on viability when evaluating a law based on these permissible goals. In short, the viability rule was created outside the ordinary course of litigation, is and always has been completely unreasoned, and fails to take account of state interests since recognized as legitimate. It is indeed telling that all other countries almost uniformly eschew a viability line. I don't like Roberts, and reading this makes me dislike Roberts even more. Only a handful of countries, among them China and North Korea, permit elective abortion after 20 weeks. The rest have coalesced around a 12-week line. Okay. The court rightly rejects the arbitrary viability rule today. Let's see here. Roberts is a politician who has been trying to preserve the policy power of the court by trying to keep cases of review. The leak blew up the thin robe line and his Weasley, we will decide the case but not overturn the constitutional violations ruling so the cases can repeat indefinitely court. That's my optimistic case. Not sure why you're defending Roe to move slowly when everyone agrees the law is bad and dissenters are just pushing policy. Because slow movement of the court is an essential part of our judicial system. That itself is an essential, necessary part. Courts need to move slowly. We cannot have Supreme Court decisions that move quickly. That it would destroy the courts. None of this, however, requires that we also take the dramatic step of altogether eliminating the abortion right first recognized in Roe. Mississippi itself previously argued as much to this court in this litigation. When the state petitioned for our review, its basic request was straightforward: clarify whether abortion prohibitions before viability are always unconstitutional. The state made a number of strong arguments that the answer is no, arguments that, as discussed, I find persuasive, and it went out of its way to make clear that it was not asking the court to repudiate entirely the right to choose whether to terminate a pregnancy. To be clear, the question presented in this petition do not require the court to overturn Roe or Casey. Mississippi tempered that statement with an oblique one-sentence footnote intimating that if the court could not reconcile Roe and Casey with current facts or other cases, it should not retain erroneous precedent. But the state never argued that we should grant a review for that purpose. After we granted certiorari, however, Mississippi changed course. In its principal brief, the state bluntly announced that the court should overrule Roe and Casey. The Constitution does not protect the right to an abortion, it argued, and a state should be able to prohibit elective abortions if a rational basis supports doing so. The court now rewards that gambit, noting 3 times that the party presented no half measures and argued that we must either reaffirm or overrule Roe and Casey. Given those 2 options, the majority picks the latter. This framing is not accurate. In its brief on the merits, Mississippi in fact argued at length that a decision simply rejecting the viability rule would result in a judgment in its favor. But even if the state had not argued as much, it would not matter. There is no rule that parties can confine this court to disposing of their case on a particular ground, let alone when review was sought and granted on a different one. Our established practice is instead not to formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. Following that fundamental principle of judicial restraint, we should begin with the narrowest basis for disposition, proceeding to consider a broader one only if necessary to resolve the case at hand. It is only where there is no valid, narrower ground of decision that we should go on to address a broader issue, such as whether a constitutional decision should be overturned. Here, there is a clear path to deciding this case correctly without overruling Roe, all the way down to the studs. Recognize that the viability line must be discarded, as the majority rightly does, and leave for another day whether to reject any right to an abortion at all. Rejecting Roe's viability line as rigid and indeterminate. Okay. Of course, such an approach would not be available if the rationale of Roe and Casey was inextricably entangled with and dependent upon the viability standard. It is not. Our precedent in this case, in this area, ground the abortion right in a woman's right to choose. And other cases recognize a constitutionally protected interest in making certain kinds of important decisions free from governmental compulsion. Lots and lots of quotes. If that is the basis for Roe's viability line should be scrutinized from the same perspective. And there is nothing inherent in the right to choose that requires it to extend to viability or any other point, so long as a real choice is provided. Again, he's making a whole different standard. And yeah, I understand he's trying to be politic, and frankly, I wish he wasn't the Chief Justice. I wish Thomas was the Chief Justice, but that's not going to happen. To be sure, in reaffirming the right to an abortion, Casey termed the viability rule Roe's central holding. Other cases of ours have repeated that language, but simply declaring it does not make it so. The question in Roe was whether there was any right to abortion in the Constitution. How far the right extended was a concern that was separate and subsidiary, and not surprisingly entirely unbriefed. Okay. The court in Roe just chose to address both issues in one opinion. It first recognized a right to choose to terminate pregnancy under the Constitution, and then, having done so, explained that a line should be drawn at viability. The viability line is a separate rule fleshing out the metes and bounds of Roe's core holding. Applying principles of stare decisis, I would excise that additional rule, and only that rule, from our jurisprudence. The majority lists a number of cases that have stressed the importance of the viability rule to our abortion precedents. I agree that whether it was originally holding or dictum, the viability line is clearly part of our past precedent, and the court has applied it as such in several cases since Roe. My point is that Roe adopted two distinct rules of constitutional law. One, that a woman has the right to choose to terminate a pregnancy. Two, that such a right may be overridden by the state's legitimate interest when the fetus is viable outside the womb. The latter is obviously distinct from the former. I would abandon that timing rule, but see no need in this case to consider the basic right. The court contends that it is impossible to address Roe's conclusion that the Constitution protects the woman's right to abortion without also addressing Roe's rule that the state's interests are not constitutionally adequate to justify a ban on abortion until viability. But we have partially overruled precedents before. I would argue Casey overruled Roe in part, but and certainly have never held that a distinct holding defining the contours of a constitutional right must be treated as part and parcel of the right itself. Overruling the subsidiary rule is sufficient to resolve this case in Mississippi's favor. The law at issue allows abortion up through 15 weeks, providing an adequate opportunity to exercise the right Roe protects. By the time a pregnant woman has reached that point, her pregnancy is well into the second trimester. Pregnancy tests are now inexpensive and accurate, and a woman ordinarily discovers she is pregnant by 6 weeks of gestation. Almost all know by the end of the first trimester. Safe and effective abortifacients, moreover, are now readily available, particularly during those early stages. Given all this, it is no surprise that the vast majority of abortions happen in the first trimester. Presumably, most of the remainder would also take place earlier if later abortions were not a legal option. Ample evidence suggests that a 15-week ban provides sufficient time, absent rare circumstances, for a woman to decide for herself whether to terminate her pregnancy. Whether a precedent should be overruled is a question entirely within the discretion of the court. In my respectful view, the sound exercise of that discretion should have led the court to resolve the case on the narrower grounds set forth above, rather than overruling Roe and Casey entirely. The court says there's no principled basis for this approach at 73, but in fact, it is firmly grounded in basic principles of stare decisis and judicial restraint. The court's decision to overrule Roe and Casey is a serious jolt to the legal system. Is it really? Regardless of how you view those cases, a narrower decision rejecting the misguided viability line would be markedly less unsettling, and nothing more is needed to decide this case. I would have overruled Casey. Our cases say that the effect of overruling precedent on reliance interest is a factor to consider in deciding whether to take such steps, and respondents argue that generations of women have relied on the right to an abortion in organizing their relationships and planning their futures. The court questions whether these concerns are pertinent under our precedents, but the issue would not even arise with a decision rejecting only the viability line. It cannot reasonably be argued that women have shaped their lives in part on the assumption that they would be able to abort up to viability as opposed to 15 weeks. In support of its holding, the court, and this is both the court's opinion and the dissent display a relentless freedom from doubt on the legal issue that I cannot share. I am not sure, for example, that a ban on terminating a pregnancy from the moment of conception must be treated the same under the Constitution as a ban after 15 weeks. A thoughtful member of this court once counseled that the difficulty of a question admonishes us to observe the wise limitations of our function and to confine ourselves to deciding only what is necessary to the disposition of the immediate case. This is Frankfurter. I would decide the question we granted review to answer, whether the previously recognized abortion right bars all abortion restrictions prior to viability, such that a ban on abortions after 15 weeks of pregnancy is necessarily unlawful. The answer to that question is no, and there's no need to go further to decide this case. I therefore concur only in the judgment. I think he was hoping for the dissenters to join on, and I don't think there was any chance of that. And here is the liberal justices and their dissent. So let's see what they say. Justice Breyer, Justice Sotomayor, and Justice Kagan dissenting. I wonder which one of them wrote it. Probably Breyer. I think he is the most senior of them. For half a century, Roe v. Wade and Planned Parenthood versus Casey have protected the liberty and equality of women. Roe held and Casey reaffirmed that the Constitution safeguards a woman's right to decide for herself whether to bear a child. Roe held and Casey reaffirmed that in the first stages of pregnancy, the government could not make the choice for women. The government could not control a woman's body or the course of a woman's life. It could not determine what the woman's future would be. Respecting a woman as an autonomous being and granting her full equality meant giving her substantial choice over this most personal and most consequential of all life decisions. What is a woman? How do I like? Men can get pregnant now, don't you know? Roe and Casey well understood the difficulty and divisiveness of the abortion issue. Last comment because I have to go. Okay. But in my opinion, the whole point of the Supreme Court is to review precedents for errors, since they have discretion to not take cases. The idea that they should act as super judges for an individual and intentionally avoid addressing the issues that led to the specific damaged individual. The cake baking cases were, they kept affirming his freedom in X cases, but then they allow it to repeat because they couldn't possibly answer the question leading to the suits because it would destroy invented rights. I think you're really misunderstanding how the Supreme Court works. They generally take cases where different district courts rule differently on the same thing. So that's the primary job of the Supreme Court, is to decide between appellate courts on issues of law. And so if all the appeals courts agree, see, the Supreme Court's job is to make the lower courts have regularity and allow predictability of their decisions, so that generally people know what the Supreme Court would say on any particular issue. That's what is basically defined by most people as their job, and I agree with that. That's historically why the whole common law English tradition of courts and rights came into being, and it's what makes it work, is the predictability of decisions. And so the reason the Supreme Court exists is so that people in different parts of the country do not get different decisions based on where they are on the same law. Okay? That's their major function. And so, so it's not there to vindicate individual rights. No individual has a right to review by the Supreme Court. I hope that was clear. Roe and Casey well understood the difficulty and divisiveness of the abortion issue. The court knew that Americans hold profoundly different views about the morality of terminating a pregnancy, even in its earliest stage, and the court recognized that the state has a legitimate interest from the outset of the pregnancy in protecting the life of the fetus that may become a child. So the court struck a balance, as it often does when values and goals compete. It held that the state could prohibit abortions after fetal viability, so long as the ban contained exceptions to safeguard a woman's life or health. It held that even before viability, the state could regulate the abortion procedure in multiple and meaningful ways. But until the viability line was crossed, the court held a state could not impose a substantial obstacle on a woman's right to elect the procedure as she, not the government, thought proper in light of all the circumstances and complexities of her own life. Today, the court discards that balance. It says that from the very moment of fertilization, a woman has no rights to speak of. You know what? I wish that that people would just be like, you know what? Okay, if that's your if that's what you're saying that we said, fine. That's what we said. That's what we're gonna do. Because then you wouldn't have these idiotic arguments, which honestly do upset me. You really believe that? A woman has no rights to speak of. A state can force her to bring a pregnancy to term, even at the steepest personal and familial costs. An abortion restriction the majority holds is permissible whenever rational, the lowest level of scrutiny known to the law, and because, as the court has often stated, protecting fetal life is rational, states will feel free to enact all manner of restrictions. The Mississippi law at issue here bars abortion after the 15th week of pregnancy. Under the majority's rule, though, another state's law could do so after 10 weeks, or 5, or 3, or 1, or again from the moment of fertilization. Okay, you know what? Let's go with it. If that's what you're saying that the holding is, let's go with it. That's your argument. So I guess that's what it is. They make these ridiculous arguments, which absolutely get me like. States have already passed such laws in anticipation of today's ruling. More will follow. Some states have enacted laws extending to all forms of abortion procedure, including taking medication in one's own home. They have passed laws without any exception for when the woman is the victim of rape or incest. Under those laws, a woman will have to bear her rapist's child or a young girl her father's, no matter if doing so will destroy her life. How would it destroy her life? See, that's the big thing. It's like it'll destroy their life. No. So too, after today's ruling, some states may compel women to carry to term a fetus with severe physical anomalies, for example, one afflicted with Tay-Sachs disease, sure to die within a few years of birth. States may even argue that a prohibition on abortion need make no provision for protecting a woman from risk of death or physical harm. Across a vast array of circumstances, a state may be able to impose its moral choice on a woman and coerce her to give birth to a child. Enforcement of all these draconian restrictions will also be left largely to the state's devices. A state can, of course, impose criminal penalties on abortion providers, including lengthy prison sentences, but some states will not stop there. Perhaps in the wake of today's decision, a state law will criminalize the woman's conduct too. It's like these ridiculous. Why do you bother even like pretending you're a judge? Why? Like this is nowhere. This is no legal reasoning whatsoever. They're not just they're not bothering. The court, as far as they're concerned, is a and as Texas has recently shown, a state can turn neighbor against neighbor, enlisting fellow citizens in the effort to root out anyone who tries to get an abortion or to assist another in doing so. The majority tries to hide the geographically expansive effects of its holding. Today's decision, the majority says, permits each state to address abortion as it pleases. That is cold comfort, of course, for the poor woman who cannot get the money to fly to a distant state for a procedure. Above all others, women lacking financial resources will suffer from today's decisions. In any event, interstate restrictions will also soon be in the offing. After this decision, some states may block women from traveling out of state to obtain abortions, or even from receiving abortions medications from out of state. Some may criminalize efforts, including the provision of information or funding to help with. What does this have to do with this decision? Most threatening of all, no language in today's decision stops the federal government from prohibiting abortions nationwide. Once again, from the moment of conception and without exceptions for rape or incest. If that happens, the views of an individual state's citizens will not matter. Are you serious? Just stop. Whatever the exact scope of coming laws, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens. Yesterday, the Constitution guaranteed that a woman confronted with an unplanned pregnancy could, within reasonable limits, make her own decisions about whether to bear a child, with all the life-transforming consequences that act it involves. And in thus safeguarding each woman's reproductive freedom, the Constitution also protected the ability of women to participate equally in this nation's economic and social life. Go away. But no longer. As of today, this court holds a state can always force a woman to give birth, prohibiting even the earliest abortions. A state can thus transform what, when freely undertaken, is a wonder into what, when forced, may be a nightmare. Some women, especially women of means, will find ways around the state's assertion of power. Others, those without money or childcare or the ability to take time off from work, will not be so fortunate. Maybe they will try an unsafe method. I don't know why they even bother. I mean, are you judges at all? And no one should be confident that this majority is done with its work. The right Roe and Casey recognized does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to turn in turn. The majority is eager to tell us today that nothing cast doubt. Thomas concurring. But how could that be the lone rationale for? Is there any legal reasoning in here at all? One piece of evidence on that score seems especially this must have been written by Sotomayor. I can't imagine anybody else writing something that is this thing. The majority's cavalier approach to overturning this court's precedents. Stare decisis is the Latin phrase for a foundation stone of the rule of law, that things decided should stay decided unless there is a very good reason for change. It is a doctrinal doctrine of judicial modesty and humility. Those qualities are not evident in today's opinion. The majority has no good reason for the upheaval. Roe and Casey haven't not. I mean, there's no argument here. The legal framework has proved workable in courts. No recent developments in either law or fact have eroded or cast. Are you insane? Are you absolutely insane? You think that Roe has been workable? Indeed, the court in Casey already found all that to be true. Casey is a precedent about precedent. It reviewed the same arguments made here in support of overruling Roe, and it found that doing so was not warranted. The court reverses course today for one reason and one reason only, because the composition of this court has changed. Stare decisis, this court has often said, contributes to the actual and perceived, yeah, it does, but okay. Today, the proclivities of individuals rule. We dissent. So that's it. I mean, this is your entire argument, or let's keep on going. We start with Roe and Casey and with their deep connection to a broad swath of the court's precedents. To hear the majority tell the tale, Roe and Casey are aberrations. They are. They came from nowhere. Correct. Went nowhere. Less so. And so are easy to excise from the nation's constitutional law. That is not true. After describing the decisions themselves, we explain how they are rooted in and themselves led to other rights, giving individuals control over their bodies and their personal intimate associations. The majority does not wish to talk about these matters for obvious reasons. They're irrelevant. To do so would both ground Roe and Casey in this court's precedents and reveal the broad implications of today's decisions. Again, there's no legal reasoning here. No legal reasoning. Some half-century ago, Roe struck down a state law making it a crime to perform an abortion unless its purpose was to save a woman's life. The Roe court knew it was treading on difficult and disputed ground. It understood that different people's experiences, values, and the court held that in the earlier stages, the court explained, what are you telling us? Where is the legal reasoning here? Where is the legal reasoning here? I see no legal reasoning here. Nothing here is anything new that hadn't been said. So Casey again struck a balance differing from Roe's in only incremental ways. It retained Roe's central holding. Okay, what does this have to do with this decision? We make one initial point about this analysis in light of the majority's insistence that Roe and Casey, and we in defending them, are dismissive of a state's interest in protecting prenatal life. Nothing could get those decisions more wrong. As just described, Roe and Casey invoked powerful state interests in that protection, operating at every stage of the pregnancy and overriding the woman's liberty after viability. The strength of those state interests is exactly why the court allowed greater restrictions. But what Roe and Casey also recognized, which today's majority does not, is that a woman's freedom and equality are likewise involved. So, what are you saying? That fact, the presence of countervailing interests, is what made the abortion question hard and what necessitated balancing. The majority scoffs at that idea, castigating us for repeatedly praising the balance the two cases arrived at, with the word balance in scare quotes. To the majority, balance is a dirty word, as moderation is a foreign concept. This must have been written by Sotomayor. Must have been. She's the only one this bad. The majority makes this change based on a single question. Did the reproductive rights recognized in Roe and Casey exist in 1868, the year when the 14th Amendment was ratified? The majority says, and with this much we agree, that the answer to this question is no. In 1868, there was no nationwide right to end a pregnancy and no thought that the 14th Amendment provided one. Of course, the majority opinion refers as well to some later and earlier history. On the one side of 1868, it goes back as far as the 13th century. Must have been written by Sotomayor. Must have been written by Sotomayor. But that turns out to be wheel spinning. First, it is not clear what relevance such early history should have even to the majority. Historical evidence that long period may not eliminate. Okay? If the early history obviously supported abortion rights, the majority would no doubt say that only. Okay, where's your Where is your reasoning? The majority's core legal postulate, then, is that we in the 21st century must read the 14th Amendment just as its ratifiers did. Yeah. And that is indeed what the majority emphasizes over and over again. Yeah, the most important historical fact is how the states regulated abortion when the 14th Amendment was adopted. Yeah. If the ratifiers did not understand something as central to freedom, then neither can we. Or, said more particularly, if those people did not understand reproductive rights as part of the guarantee of liberty conferred in the 14th Amendment, then those rights do not exist in the 14th Amendment. As an initial matter, note a mistake in the just preceding sentence. We referred there to the people who ratified the 14th Amendment. What rights did those people have in their heads at the time? But of course, people did not ratify the 14th Amendment. Men did. Oh my God. Wow. Yeah, this could only have been written by Sotomayor. So it is perhaps not so surprising that the ratifiers were not perfectly attuned to the importance of. Casey itself understood this point, as will become clear. It recollected that with dismay, a decision this court issued just 5 years after the 14th Amendment's ratification, approving a state's decision to deny a law license to a woman and suggesting as well that a woman had no legal status apart from her husband. I don't even remember Bradwell. There was a time, Casey explained, when the Constitution did not protect men and women alike. But times had changed, a woman's place in society had changed, and constitutional law had changed along with it. The relegation of women to inferior status in either the public sphere or the family was no longer consistent with our understanding of the Constitution. Now the Constitution protects all individuals, male or female. So how is it that, as Casey said, our Constitution read now grants rights to women, though it did not in 1868? How is it that our Constitution subjects discrimination against them to heightened judicial scrutiny? How is it that our Constitution, through the 14th Amendment, Liberty Clause, guarantees access to contraception, also not legally protected in 1868, so that women can decide for themselves? How is it that until today, that same constitutional clause protected a woman's rights, right, in the event? If you don't know the answer to this question, I have to wonder why you're on our Supreme Court. The answer is that this court has rejected the majority's pinched view of how to read our Constitution. The founders, we recently wrote, knew they were writing a document designed to apply to ever-changing circumstances over centuries. Or in the words of the great Chief Justice John Marshall, our Constitution is intended to endure for ages to come and must adapt itself to a future seen dimly, if at all. That is indeed why our Constitution is written as it is. The framers, both in 1788 and 1868, understood that the world changes. So they did not define rights by reference to the specific practices existing at the time. Instead, the framers defined rights in general terms to permit future evolution in their scope and meaning. And over the course of our history, this court has taken up the framers' invitation. It has kept true to the framers' principles by applying them in new ways, responsive to new societal understandings and conditions. What's the new societal understanding and condition which allows abortion? Okay, you're saying there's something new here. What's new here? What's new here? Nowhere has that approach been more prevalent than in construing the majestic but open-ended words of the 14th Amendment, the guarantees of liberty and equality for all. And nowhere has that approach produced prouder moments for this country and the court. Consider an example Obergefell used a few years ago. The court then confronted a claim based on Washington versus Glucksberg that the 14th Amendment must be defined in a most circumscribed manner with central reference to specific historical practices, exactly the view today's majority follows. Obergefell and the court specifically rejected that view. In doing so, the court reflected on what the proposed historically circumscribed approach would have meant for interracial marriage. The 14th Amendment's ratifiers did not think it gave black and white people a right to marry each other. To the contrary, contemporaneous practice deemed that act quite as unprotected as abortion. Yet the court in Loving versus Virginia read the 14th Amendment to embrace the Loving's union. If Obergefell explained rights were defined by who exercised them in the past, then received practices could serve as their own continued justification, even when they conflict with liberty and equality as later and more broadly understood. The Constitution does not freeze for all time the original view of what those rights guarantee or how they apply. That does not mean anything goes, doesn't it? Doesn't it though? The majority wishes people to think that there are two alternatives: accept the original application of the 14th Amendment and no other, or surrender to judges' own ardent views ungrounded in law about the liberty that Americans should enjoy. At least that idea is what the majority sometimes tries to convey. At other times, the majority, or rather most of it, tries to assure the public that it has no design on rights, for example, to contraception, that arose only in the back half of the 20th century, in other words. Honestly, for now, our point is different. It is that application of liberty and equality can evolve while remaining grounded in constitutional principles, constitutional history, and constitutional precedents. The second, Justice Harlan discussed how to strike the right balance when he explained why he would have invalidated a state's ban on contraceptive use. Judges, he said, are not free to roam where unguided speculation might take them. Yet they also must recognize that the constitutional tradition of this country is not captured whole at a single moment. Rather, its meaning gains content from the long sweep of our history, from successive judicial precedents, each looking to the last and each seeking to apply the Constitution's most fundamental commitments to new conditions. That is why Americans, to go back to Obergefell's example, have a right to marry across racial lines. And it is why, to go back to Justice Harlan's case, Americans have a right to use contraceptives so they can choose for themselves whether to have children. All that is what Casey understood. Casey explicitly rejected the present majority's method. The specific practices of states at the time of the adoption of the 14th Amendment, Casey stated, do not mark the outer limits of the substantive sphere of liberty which the 14th Amendment protects. To hold otherwise, as the majority does today, would be inconsistent with our law. Why? Because the court has vindicated the principle over and over that no matter the sentiment in 1868, there is a realm of personal liberty which the government may not enter, especially relating to bodily integrity and family life. Casey described in detail the court's contraception cases. It noted decisions protecting the right to marry, including to someone of another race. Interracial marriage was illegal in most states in the 19th century, but the court was no doubt correct in its finding to in finding it to be an aspect of liberty protected against state interference. In reviewing decades and decades of constitutional law, Casey could draw but one conclusion: whatever was true in 1868, it is settled now, as it was when the court heard arguments in Roe v. Wade, that the Constitution places limits on a state's right to interfere with a person's most basic decisions about family and parenthood. And that conclusion still held good until the court's intervention here. It was settled at the time of Roe, settled at the time of Casey, and settled yesterday that the Constitution places limits on a state's power to assert control over an individual's body and most personal decision making. A multitude of decisions supporting that principle led to Roe's, and on they're arguing against a straw man. And eliminating that right, we need to say, before further describing our precedents, is not taking a neutral position, as Justice Kavanaugh tries to argue. His idea is that neutrality lies in giving the abortion issue to the states, where some can go one way and some another. But would he say that the court is being scrupulously neutral if it allowed New York and California to ban all the guns they want? Great. If the court allowed some states to use unanimous juries and others not, if the court told the states, decide for yourselves whether to put restrictions on church attendance, we could go on, and in fact we will. Suppose Justice Kavanaugh were to say, in line with the majority, I don't know why I'm bothering with this. They're not even bothering. I see no legal reasoning here. None. Over the course of 3 cases, the court has held that a right to use and gain access to contraception was part of the 14th Amendment's guarantee of liberty. That clause, we explain, necessarily conferred a right to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. They're arguing against a straw man. Nobody's saying that the 14th Amendment doesn't guarantee any rights at all. Nobody's I honestly don't know how to the first, should the audience for did they bother with legal consider as our last word on this issue contraception. The Constitution, of course, does not mention that word, and there's no historical right to contraception of the kind the majority insists on. To the contrary, the American legal landscape, right, there is no legal constitution, that there is no right to contraception. If the majority is serious about its historical approach, then Griswold and its progeny are in the line of fire too. Or if it is not serious, then what is the basis of today's decision? If we had to guess, we suspect the prospects of this court's approving bans on contraception are low, but once again, the future significance of today's opinion will be decided in the future. At the least, today's opinion will fuel the fight to get contraception and any other issue with a moral dimension out of the 14th Amendment and into state legislatures. Zero legal reasoning. Zero legal reasoning. As a matter of constitutional substance, the majority's opinion has all the flaws its method would suggest. Because laws in 1868 deprived women of any control over their bodies, the majority approves states doing so today. Because those laws prevented women from charting the course of their own lives, this is just polemic. By overruling Roe, Casey, and more than 20 cases reaffirming or applying the constitutional right to abortion, the majority abandons stare decisis, a principle central to the rule of law. I'm just trying to find the majority is wrong when it says that we insist on a test of changed law or fact alone, although that is present in most of the cases. None of these factors apply here. Nothing, and in particular, no significant legal or factual change supports overturning a half century of settled law giving women control over their reproductive. Like, where did they get this rule from? The court found, for example, like, just tell me what your rule is for stare decisis and how you apply it here, right? Please. First, for all the reasons we have given, Roe and Casey were correct in holding that a state could not resolve the debate about abortion in such a definitive way that a woman lacked all choice in the matter. The court protected women's liberty and women's equality in a way comporting with our 14th Amendment precedents. Contrary to the majority's view, the legal status of abortion in the 19th century does not weaken those decisions. And the majority's repeated refrain about usurping state legislatures' power to address a publicly contested question. To repeat, the point of the right is to shield from vicissitudes, however divisive a right is not at. Well, okay, this is correct, that no matter how politically divisive a right is, it cannot be a thing. That is correct. The court has to maintain it. That's the first thing they've said that's actually correct. And it's what everybody like on their side is disagreeing with all over Twitter. Whether or not we agree with a prior is the beginning, not the end of our analysis, and the remaining principles of stare weigh heavily against overruling Casey. Casey applied those principles in one of this court's most important precedents about precedent. After assessing the traditional stare decisis factors, Casey reached the only conclusion possible, that stare decisis operates powerfully here. It still does. The standards Roe and Casey set out are perfectly workable. No changes in either law or fact have eroded the two decisions, and tens of millions of American women have relied and continue to rely on the right to choose. So under traditional stare decisis principles, the majority has no special justification for the harm it causes. And indeed, the majority comes close to conceding that point. The majority barely mentions any legal or factual changes that have occurred since Roe and Casey. It suggests that the two decisions are hard for courts to implement, but cannot prove its case. Really? Really? In the end, the majority says all it must say to override stare decisis is one thing, that it believes Roe and Casey egregiously wrong. That rule could equally spell the end of any precedent with which a bare majority of the court disagrees. I have to agree with them on that point. It makes rather too fast. Well, it's funny that they're arguing this because they obviously don't believe it. Contrary to the majority's view, there's nothing unworkable about Casey's undue burden standard. Its primary focus on whether a state has placed a substantial obstacle on a woman seeking an abortion is the sort of inquiry familiar to judges across a variety of contexts. Roberts himself, okay? And it has given rise to no more conflict in application than many standards this course and others hesitatingly apply every day. Really? Really? I mean, you're really arguing that anyone concerned about workability should consider the majority substitute standard. The majority says a law regulating or banning abortion must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. And the majority lists interests like respect for and preservation of prenatal life. Okay. I don't see what they're saying, what they're arguing at all. Like, this is just a bunch of hypotheticals that could possibly, like, happen, maybe. The Constitution protects travel and speech and interstate commerce, so today's ruling will give rise to a host of new constitutional questions. Far from removing the court from the abortion issue, the majority puts the court at the center of the coming interjurisdictional abortion wars. Wrong. I mean, this is obviously wrong. This is just factually wrong. The problem is obviously that the pro-life, pro-choice debate, which is a political question, is being brought before the court constantly, and it shouldn't be. And part of the problem is that it is, in fact, I mean, honestly, this whole argument that they're making just shows how correct Thomas is, because none of these arguments apply to his correct decision, which is why they're not even talking about it, I guess. When overruling constitutional precedent, the court has almost always pointed to major legal or factual changes undermining a decision's original basis. A review of the appendix to this dissent proves the point. Most successful proponents of overruling precedent, this court once said, have carried the heavy burden of persuading the court that changes in society or in the law dictate that the values served by stare decisis yield in favor of a greater objective. Vasquez, what year was Vasquez decided? I'm surprised it doesn't say right there what year Vasquez was decided. Certainly that was so of the main examples of the majority cites, Brown and Parrish. But it is not so today, although nodding to some arguments others have made about modern developments, the majority does not really rely on them, no doubt seeing their slimness. Honestly, the technology change has been huge, and if they wanted to, they could have relied on it, but it would have been bad reason to rely on it. It's not thin. The technology differences are huge. The scientific knowledge differences are huge. Subsequent legal developments have only reinforced Roe and Casey. The court has continued to embrace all the decisions Roe and Casey cited, decisions which recognize a constitutional right for an individual to make her own choices about intimate relationships, the family, and contraception. Roe and Casey have themselves formed the legal foundation for subsequent decisions protecting those profoundly personal choices. As discussed earlier, the court relied on Casey to hold that the 14th Amendment protects same sex intimate relationships, which is another thing which I find is ridiculous. No substantive. The zero legal. Experts estimate that a ban on abortions increases maternal mortality by 21%, with white women facing a 13% increase in maternal mortality, while black women face a 33% increase. 13. C. Harris, Navigating Loss of Abortion Services, a large academic medical center, prepares for the overturn of Roe v. Wade, and I'm guessing this was written after the leak. This projected racial disparity reflects existing differences in maternal mortality rates for black and white women. Black women are now, it's not, no legal reasoning. The majority briefly notes the growing prevalence of safe haven laws and demand for adoption, and but to the degree that these are changes at all, they too are irrelevant. Are they? Neither reduces the health risks or financial cost of going through pregnancy and childbirth. Moreover, the choice to give up parental rights after giving birth is altogether different from the choice not to carry a pregnancy to term. The reality is that few women denied an abortion will choose adoption. Okay. The vast majority will continue just as to shoulder the costs of child rearing. Whether or not they choose to parent, they will experience the profound loss of autonomy and dignity that coerced pregnancy and birth always impose. I'm just trying to find a place where they actually use some legal reasoning, which is the only notable change we can see since cuts in favor of adhering to precedent is that American abortion law has become more and more aligned with other nations. The majority, like the Mississippi legislature, claims that the United States is an extreme outlier when it comes to abortion regulation. It is. The global trend, however, has been toward increased provision of legal and safe abortion care. A number of countries, including New Zealand, the Netherlands, and Iceland, permit abortions up to a roughly similar time as Roe and Casey set. Canada has decriminalized abortion at any point in a pregnancy. Most Western European countries impose restrictions on abortions after 12 to 14 weeks, but they often have liberal exceptions to those time limits, including to prevent harm to a woman's physical or mental health. Again, I don't see thing. Um, both those decisions, unlike today's, respond to changed law and to changed facts and attitudes that had taken hold throughout society. I don't see how this is relevant. I mean, if you're going to make an argument about what the terms of stare decisis should be, make an argument, make a legal argument about the terms of stare decisis, but they're not going to make that because it would cut against them in the future. Um, the disruption of overturning Roe and Casey will therefore be profound. Yeah, it will. Abortion is a common medical procedure and a familiar experience in women's lives, unfortunately. About 18% of pregnancies in this country end in an abortion. And about 1/4 of American women will have an abortion before the age of 45. That's part of the problem here. Those numbers reflect yeah, I mean, I don't think there's any question that this is a weighty issue. I don't understand what their point is. The majority of reproductive planning could take virtually immediate account of any sudden restoration of state authorities. Yeah, I mean, 45% of pregnancies in the United States are unplanned. Unfortunately, people should be having more children. But that's, again, I don't see their legal reasoning. Appeal to poor women. Finally, the expectation of reproductive control is integral to many women's identity and their place in the nation. That expectation helps define a woman as an equal citizen with all the rights, privileges, and obligations that status entails. It reflects that she is an autonomous person and that society and the law recognize her as such. And nobody's saying women don't have rights anymore. Well, except the new Justice Ketanji Brown Jackson doesn't know what a woman is. Withdrawing a woman's right to choose whether to continue a pregnancy does not mean that no choice is being made. It means that the majority of today's court has wrenched this choice from women and given it to the states. To allow a state to exert control over one of the most intimate and personal choices. And I mean, this is all just proving Thomas's point. The majority claims that the reliance interests women have in Roe and Casey are too intangible for the court to consider, even if it were inclined to do so. This is to ignore as judges what we know as men and women. The interests women have in Roe and Casey are perfectly, viscerally concrete. Countless women will now make different choices about careers, education, relationships, and whether to try to become pregnant than they would have when Roe served as a backstop. Yeah. Other women will carry pregnancies to term. Yeah. Again, where's the legal reasoning? A reliance interest is not just that things will be different, but that your reliance on it, that you made decisions already in reliance. And this is so let's talk reliance interest, because that's actually a legal concept. So let's say that right now, marijuana was, well, let's do alcohol, right? So alcohol is legal in the United States. There are people who have liquor stores, people who have whose whole job depends on alcohol, bartenders, all kinds of stuff, right? And if that were to change, right, then all these businesses would have to change their business. All people who have made decisions within their life in a certain way would be in a situation they could not have predicted. Okay. Contrast that to a reliance interest on abortion. The only reliance interest on abortion you might have is, I married somebody that I wouldn't have married before because I knew I could get an abortion. Like, that's a reliance interest. After today, young women will come of age with fewer rights than their mothers and grandmothers had. The majority accomplishes that result without so much as considering how women have relied on the right to choose, or what it means to take that right away. Again, they're talking about people coming of age. It's like, what are you talking about? One last consideration counsels against the majority's ruling: the very controversy surrounding Roe and Casey. The majority accuses Casey of acting outside the bounds of the law to quell the conflict over abortion, of imposing an unprincipled settlement of an issue in an effort to end national division. But that is not what Casey did. As shown above, Casey applied traditional principles of stare decisis, which the majority today ignores. In reaffirming Roe, Casey carefully assessed changed circumstances and considered. What are you telling me? Power, not reason, is the new currency of this court's decision making. Roe has stood for 50 years. Casey, a precedent about precedent, specifically confirming Roe, has stood for 30. And the doctrine of stare decisis, a critical element of the rule of law, stands foursquare behind their continued existence. The right those decisions established and preserved is embedded in our constitutional law. Again, this is an argument only about stare decisis. Yet this must have been Sotomayor. Nobody else could have written an argument this bad. Ginsburg. Sotomayor and earlier this term, this court signaled that Mississippi's stratagem would succeed. Texas was one of the fistful of states to have recently banned abortions after 6 weeks of pregnancy. It added to that flagrantly unconstitutional restriction an unprecedented scheme to evade judicial scrutiny. And 5 justices acceded to that cynical maneuver. They let Texas defy the court's constitutional rulings. nullifying Roe and Casey ahead of schedule in the nation's second largest state. And now the other shoe drops, courtesy of that same 5% majority. We believe that the Chief Justice's opinion is wrong too, but no one should think that there is not a large difference between upholding a 15-week ban on the grounds he does and allowing states to prohibit abortion from the time of conception. Then maybe you could have taken up his offer, which you didn't, of having some sort of compromise, which you won't take now. And you, which, I mean, obviously, I think he's taking the wrong tack. He's a David French conservative, and we have to understand that these are not David French times. Let's see. People have been saying things. I am not sure what you are talking about since it's been like 15 minutes. That could happen, but has never happened before. The point isn't to give legal reasoning, it's to give activists things to go, quote. Yup. Basically, if we had that sort of constitutional weirdness, like pre-Civil War with slavery, that would be a good reason to, I don't know, actually force a constitutional amendment. Right. So that's a big part of this is, yeah. It's a completely political argument from completely political appointees, which honestly, the Republicans should have. The court's been messed up. And the fact we have people like Sotomayor is just more messed up. I don't know what to tell you. Wow. Okay, so let's read this. Casey itself made the last point in explaining why it would not overrule Roe, though some members of its majority might not have joined Roe in the first instance. Just as we did here, Casey explained the importance of stare decisis, the inappositeness of West Coast Hotel and Brown, the absence of any changed circumstances justifying the reversal of precedent. The court, Casey explained, could not pretend that overruling Roe had any justification beyond a present doctrinal disposition to come out differently from the court of 1973. And to overrule for that reason, quoting Justice Stewart, Casey explained that to do so, to reverse prior law upon a ground no firmer than a change in the court's membership, would invite the view that this institution is little different from the two political branches of the government. Unfortunately, that's what you're proving right now. No view, Casey thought, could do more lasting injury to this court and to the system of law which it is our abiding mission to serve. For overruling Roe, Casey concluded the court would pay a terrible price. The justices who wrote those words, O'Connor, Kennedy, and Souter, they were judges of wisdom. They would not have won any contest for the kind of ideological purity some court watchers want justices to deliver, like you're delivering right now. But if there were awards for justices who left this court better than they found it, and who for that reason left this country better, and the rule of law stronger, sign those justices up and not you. They knew that the legitimacy is earned over time. They also would have recognized that it can be destroyed much more quickly. They worked hard to avert the outcome in Casey. The American public, they thought, should never conclude that its constitutional protections hung by a thread. That's correct. That a new majority adhering to new doctrinal schools could, by dint of numbers alone, expunge their numbers. It is hard, no, it is impossible to conclude that anything else has happened here. I mean, one of us once said that it is not often in the law that so few have so quickly changed so much, Breyer. For all of us in our time on this court, that has never been more true than today. In overruling Roe and Casey, the court betrays its guiding principles. You didn't actually make any argument whatsoever. With sorrow for this court, but more for the many millions of American women who have today lost a fundamental Constitution protection, we dissent. Oh, God. I expected better. Frankly, I expected Kagan to write the decision, and she is actually competent, and would have hopefully made a legal argument that might be sustainable, but I guess not. Oh, this is my view on Nancy Pelosi. Yeah, she's a devout Catholic. Okay. Yay, Clinton is trending. So let's see what Ms. Clinton has to say. Most Americans believe the decision to have a child is one of the most sacred decisions there is, and that such decisions should remain between patients and their doctors. Today's Supreme Court opinion will live in infamy as a step backward for women's rights and human rights. Well, there's a lot of argument going on, apparently. Have to ask, what is a woman? Protests break out across the U.S. after Supreme Court overturns Roe v. Wade. If Hillary Clinton would have won in 2016, the Supreme Court would have mandated forced abortions today. Today, the Supreme Court not only reversed nearly 50 years of precedent, it relegated the most intensely personal decision someone can make to the whims of politicians and ideologues, attacking the essential freedoms of millions of Americans. Shout outs to all the people who didn't vote for Hillary Clinton because they didn't see the point in voting for the lesser of two evils. It'd be nice if evil was a bit lesser today. I mean, that much is true. Trump winning really did make it. If not for this man, Hillary Clinton would have appointed 3 liberal anti-life activist judges. Correct. If not for this man, Roe would still be intact. She misspelled intact. Well, intact is one word, not 2 words. If not for this man, millions would be killed in the name of choice. Thank you, President Trump. Hillary, I'm thankful for you. I sincerely mean that. Thank you for giving us President Trump and 3 Supreme Court justices. Pacific always has good things. Roe v. Wade is relegated to the ash heap of history, like the rest of the immoral 70s legacy of hippie movement, free sex revolution, and Hillary Clinton's pants. Uh, Baby lives matter. So, actually, let me listen to this with you guys. Hopefully, you'll be able to hear this. I think you'll be able to hear this when I
see the court overturn. You just said you want to see the court protect the Second Amendment. Do you want to see the court overturn Roe
Well,
v.
if
Wade?
we put another 2 or perhaps 3 justices on, that's really what's going to be, that's will happen. And that'll happen automatically, in my opinion, because I am putting pro-life justices on the court. I will say this, it will go back to the states, and the states will then make a determination.
Donald has said he's in favor of defunding Planned Parenthood. He even supported shutting the government down to defund Planned Parenthood. I will defend Planned Parenthood. I will defend Roe v. Wade, and I will defend women's rights to make their own healthcare decisions.
Secretary,
and we have come too far to have that turn back now. And indeed, he said women should be punished, that there should be some form of punishment for women who obtain abortions. And I could just not be more opposed to that kind of thinking.
If you go with what Hillary is saying, in the 9th month, you can take the baby and rip the baby out of the womb of the mother just prior to the birth of the baby. Now, you can say that that's okay, and Hillary can say that that's okay, but it's not okay with me. Because based on what she's saying and based on where she's going and where she's been, you can take the baby and rip the baby out of the womb in the 9th month on the final day. And that's not acceptable.
Well, that is not what happens in these cases. And using that kind of scare rhetoric is just terribly unfortunate. You should meet with some of the women that I've met with, women I've known over the course of my life. This is one of the worst possible choices that any woman and her family has to make.
Abortion.
And I do not believe the government should be making it. And I can tell you the government has no business in the decisions that women make with their families in accordance with their faith, with medical advice. And I will stand up for that right.
Nobody has business doing what I just said, doing that as late as 1 or 2 or 3 or 4 days prior to birth. Nobody has that.
All right. Do you want to?
During the debates, she actually defended partial birth abortions in ways I found absolutely shocking and crazy. And nobody called her out on it. Monica Lewinsky. Okay. Okay, people. If nobody has anything to say and nobody wants to join me in the discussion, then I am going to log off in Okay, people, I am logging off. Talk to you later.